Justice James Omotosho of the Federal High Court sitting in Abuja on Friday ruled that the detained Biafra agitation leader, Nnamdi Kanu, has case to answer, because the Nigeria government prosecution team have provided some evidence that requires explanations from the detained Biafra leader. The coordinating lawyer to Nnamdi Kanu, Barrister Aloy Ejimakor, said the judgment of the court does not mean Nnamdi Kanu has been pronounced guilty. Rather, the ruling indicated that he should give explanations to certain evidences the federal government of Nigeria brought before the court. It would be recalled that the ruling on the no-case submission filed by Nnamdi Kanu that was earlier slated to be held on October 10, 2025 was abridged and rescheduled to Friday, the 26th of September 2025. Justice James Omotosho also rejected request by Kanu to be transferred from custody of the Department of State Services, DSS, to the National Hospital Abuja for medical examination over alleged deteriorating health issues. The court subsequently ordered the President of Nigerian Medical Association, NMA, to constitute an investigation committee to examine Kanu's medical condition and submit a report to it in 8 days following objection by DSS to his request to be transferred to National Hospital for second opinion on his health condition. We had earlier in the year reported that the case between the federal government of Nigeria and the detained leader of the indigenous people of Biafra, Nnamdi Kanu, apparently took a new technical twist after one of the lawyers of the detained Biafra leader, Paul Erikoro, San, presented and played 3 videos which the Federal High Court sitting in Abuja later admitted in evidence. The videos of former Nigeria Chief of Army Staff, retired General Theophilus Danjuma, saying, "Security operatives in the West Africa country, specifically, the armed forces are working together with the armed bandits to kill Nigerians," stressing that, if Nigerians depend on the armed forces to curb insecurity, they will all die one by one. Also that of Governor Hope Uzodinma of Imo State, saying, "Politicians are behind killings in the state." Lastly, and the most interesting video played at the court to counter the testimony or statement made by the DSS prosecutor witness over Nnamdi Kanu-led IPOB founding Eastern Security Network, ESN, allegedly created by a group of youths in the southeastern geopolitical zone of Nigeria, often referred to as Biafra Land, to fight in self-defense against Fulani armed bandits or terrorists that were advancing and killing people in the eastern states during the era of President Muhammadu Buhari, was that of the Director General of the Department of State Services, DSS, Adeola Ajayi, who is apparently the government chief complainer in the case, and the DSS DG in the video recorded and published by Symphony News Media in February 2025, narrated how youths of the Azare community in Katagum local government area and Tafawa Balewa community of Tafawa Balewa local government area in Bauchi State, when the DSS DG was the State Director of State Security Services, SSS, resorted to self-help and killed all Boko Haram terrorists that came to attack them without depending on the security operatives. According to the DSS DG, when Boko Haram terrorists invaded Azare community, they started shooting and killing people. Then, the youths went after the Boko Haram terrorists and killed all of them, even when one of the Boko Haram terrorists named Khalid climbed a tree and started firing gunshots from the tree towards the people who were on the lower ground. The Azare people resisted and went after him and subsequently killed him, although the federal government prosecution witness identified as BBB, who is a DSS operative, stated that the ESN is an illegal organization because there is no approval of government given to the people of Southeast to establish such a self-help group to defend their land against terrorists, unlike a Motecan security network in the southwest states that was approved and permitted by the government. Also claiming, his boss, the DSS DG in the video, was asking communities to build the first line of defense by thus working with security operatives, but a careful and detailed study of the DSS DG speech in the video shows that the FG witness, BBB, probably talked off points, totally off-key from the original intent and intention of Mr. Adeola Ajayi, the DSS DG teachings and advise in the video, who had said the Azare community people acted in quick response to an emergency situation, and the storyline indicated that the people of Azare prepared themselves in advance, likely purchasing and acquiring firearms equivalent to AK-47 rifles to be able to face and kill all the Boko Haram terrorists that invaded the community, as narrated by the DSSDG. And if true, the DSSDG, the chief complainer, must also be ordered to appear before the court as a defender in the case to present a certified true copy of government approval given to Azare people to defend themselves, or prove beyond reasonable doubts how the people of Azare community were able to kill, merely with the bare hands, all the Boko Haram terrorists that invaded their community with high-precision weapons of mass destructions. In addition, the DSSDG in the video probably advocated for the need for all individuals in Nigeria to have a gun, because he gave an example of a visit to the United States of America, USA, when his host in the US heard a police siren sound. He quickly brought out his gun and said, if the criminal chased after by the US police ran into his apartment, he would use the gun to kill the criminal suspect, and that not all. The DSSDG in the video also recalled and referenced the words of Nigeria former head of state, retired General Ibrahim Badamasi Babangida, that if insecurity must end in Nigeria, Nigerians must be ready to resort to self-help like the people of Azare community did.
The ruling is simply requires Mazi Nnamdi Kanu, the defendant, to enter his defense. It's not a pronunciation of guilt or not guilty. So that is why it's called a no-case submission. So the judge made a ruling that there's a prima facie evidence that needs to be explained. So in common parlance, it calls on him to come and mount his own defense. But there is the other aspect of the ruling that concerned extraordinary rendition. That very one is one that compounded us, because the extraordinary rendition of Mazi Nnamdi Kanu is so open and notorious. Two international institutions or two separate panels of the United Nations have made pronouncements regarding his extraordinary rendition and called for his unconditional release. Nigeria is a member of the United Nations and therefore bound to consider that and implement that decision. And in Nigeria here, 3 courts have made similar pronouncements. First was by the Federal High Court of Umuahia, which awarded him 500 million naira. And the Court of Appeal also pronounced that he was a victim of extraordinary rendition. And in the Supreme Court, the same Supreme Court that sent this case back to trial, reached the same conclusion, that he was a victim of extraordinary rendition. And all these things are of the record. They are all in the file. And we remember when this trial was being conducted, these very documents were tendered in evidence. So it compounded us, it confused us, that the court now made a pronouncement that the extraordinary rendition had no evidence before the court, that no evidence of it was submitted before the court. And you remember, least but not the last, recently a Kenyan High Court made the same pronouncement. But well, if the court was misled by believing by mistake that these things were not in evidence, it also said and left the door open that such evidence be submitted. So we are coming back with that evidence, and it's going to be quantum and legion.
What about the first application on the enemy?
Well, that one too, it wasn't in evidence that the Nigerian Medical Association has intervened. So it came as a surprise. Well, there's a short date given of 8 days for the NMA to submit its report. So somebody is ill, I don't think NIA is going to change much of that. But I think the judge wanted to leave the record open to admit every possible evidence regarding this matter. But meantime, we are disappointed. Our client remains ill and remains detained. And we're not happy about that. His situation requires urgent and emergent care. So whatever the court says today does not mean that the government shall withdraw back. Just 2 days ago, I wrote a letter. A private hospital has also expressed readiness to admit him here in Abuja. For security reasons, I won't mention the name of the private hospital. But the government, if the government appears to have issues with taking him to the national hospital, we have given them an option of a private hospital also here in Abuja.
So it's safe to say that the application to be transferred to the national hospital was rejected?
Rejected? No, it's pending. Yes.
One other information.
It hasn't been rejected. It's pending. It's pending the admission of this report from the Nigerian Medical Association and the opinion of Nigerian Medical Association. And if you were in court, the judge had ordered that the committee or panel to be considered by the Nigerian Medical Association shall have a member from the National Hospital. So National Hospital is still in play.
Bringing you the news in a more digital way.